Are you a board member or are you a managing director and you want to know whether it's worthwhile defending yourself against a termination under German law or whether you are eligible for a severance pay? My name is Asma Hussain-Hämäläinen. I'm an attorney at law and specialist in labor law. I'm available from Monday till Sunday from 7 a.m. till 9 p.m. for an individual consultation. I will explain to you 4 scenarios and you will understand a little bit how difficult the whole topic around managing directors and termination is. First scenario. You have a written MD contract and you have also worked as a managing director. So this means you have given instructions, you have not taken instructions. In this case, the courts say you have termination protection only if you have agreed to this in the contract and otherwise just a weak termination protection and not the strong Kündigungsschutzgesetz, the strong termination protection. Second case. You have a written managing director's contract, but you have not worked as a managing director. You have worked as an employee. You have taken instructions. Okay? In this case, the courts say, no matter what the contract says, you are an employee, which is great because then you can benefit from the termination protection law. Third scenario. You have an employment contract. So this means your contract says you are an Angestellter, Mitarbeiter. You have all these laws and regulations in this about vacation, where you have to work, when you have to do your duties, what you have to do when you're on sick leave, all these typical things that are in the employment contract. And if in reality you have worked as an MD, even though you have an employment contract, and you have maybe even been registered in the commercial register as a managing director, the courts say you are an employee because the contract now says employment contract. It's the opposite of what the courts say in the other case. You see, the German courts are very employee friendly, which is good. Fourth case, both can be together. You can at the same time in a company be managing director and employee, but just in different entities. For example, in the parent company, you are an employee, and the subsidiary, you are a managing director. Or in the sister company, you are a managing director, and the other sister company, you are an employee. It's very important for the termination protection, and this means for your severance pay, if you find out an employment relationship which is still alive or that can be revived. If you now think, wow, this is all very difficult and very complicated, this is true. I'll be available for you for an individual consultation with your specific contract from Monday till Sunday from 7 a.m. till 9 p.m. I'll be happy to advise you.